All right. Now, in these brief comments, I want to question not the accuracy of his organizational structure, but its relevance, which, to be clear, is not to claim that it is irrelevant. Instead, I want to evaluate its potential relevance by bringing to bear insights of original public meaning originalism, the methodology that has come to prominence in recent years, but which Burt does not mention in his piece. So in particular, what I want to examine is, I want to examine his thesis in light of the recently rediscovered, yet traditional distinction between constitutional interpretation on the one hand and constitutional construction on the other. Now, according to this distinction, interpreting the text of the Constitution involves ascertaining its meaning. Put another way, interpretation attempts to identify the information that the text conveyed to a member of the general public at the time the measure was enacted. Now, although this I just skipped a line. Interpretation, let me go back. Interpretation attempts to identify the information that was included in this particular text. Original public meaning interpretation, sometimes called the new originalism, seeks the information that the text conveyed to a member of the general public at the time it was enacted. Now, although this interpretive inquiry is complicated by the occasional use of legal terms of art, think letters of marque and reprisal, for example, that may have had no general public meaning, I'm going to put that complication to one side. Originalists may disagree amongst themselves on exactly how this inquiry is supposed to be conducted, and as well as on particular claims about original public meaning, but they all share a common quest: ascertaining the information that was conveyed by the text in context at the time it was enacted. But originalists today acknowledge that the information conveyed by the text itself may be insufficient to resolve a particular case or controversy, in which case interpretation, strictly speaking, has come to an end, and what is called constitutional construction must begin. Constitutional construction is the activity of putting the information that the text does contain into action. To give a non-controversial example, while the Constitution forbids statutes that abridge the freedom of speech and assembly, it is necessary to tell whether any or every particular law that may restrict speech is in fact an abridgment. For example, regulations of the time, place, and manner by which the rights of speech or assembly are exercised do not improperly abridge the freedom of speech, but instead coordinate the exercise of this right with the rightful liberties of others in society. Similar doctrines have been developed to handle problems concerning, for example, the free exercise of religion. Indeed, an elaborate doctrinal apparatus has evolved over the years to decide particular First Amendment cases. None of these rules can be found, either expressly or by implication, in the text of the First Amendment itself. Yet all are necessary to put what is in the text of the First Amendment into effect. This development of constitutional doctrine, to put the text into effect, is what we refer to as constitutional law, as opposed to the Constitution itself. Insofar as it cannot be deduced from the text itself, sometimes it can, but most often it cannot, most of what the Supreme Court does when it develops this doctrine is actually construction rather than interpretation. So the commonly made objection, just where in the Constitution does it say that, falls flat when one is in what Professor Larry Solem has called the construction zone, where you only go when the information provided by the text has run out. True, some contend that where the information contained in the text runs out, judges should remain silent and let the so-called representative branches make their own choices. But this claim is itself a constitutional construction that appears nowhere in the text, which only goes to show that no matter how much information may be conveyed by a particular text and discovered by interpretation, construction is needed at least some of the time to finish the job. Now, how one is supposed to do constitutional construction is an interesting and controversial issue. In my experience, different people approach the enterprise of constitutional construction differently depending on their extra-textual theory of constitutional legitimacy. By this I mean what they believe makes a constitution binding. If you think the Constitution's legitimacy is based on its original or ongoing consent by the people, For example, you may adopt different rules of construction than if you think it is based on its procedural assurances that the laws imposed on people who have not consented do not violate their rights. But however they do constitutional construction, all originalists agree that constitutional construction can only be used to apply or supplement original meaning. It cannot be used to contradict or trump original meaning. Now, as many of you know, there's a lot more to say about this than I can say in these few minutes. My point in sketching the distinction between interpretation and construction is to highlight the following question with respect to Burt's holistic reading of the Bill of Rights. Is it an exercise in interpretation, or is it an exercise in construction? Now, I think it could be either or both. A holistic reading of the Bill of Rights is interpretive if it reveals something about the original public meaning of the text. That is, it uncovers information that is actually in the text, that is part of its public meaning. Now, that is certainly possible. To give one example that he doesn't discuss in his paper, the fact that the Ninth Amendment refers to rights and the Tenth Amendment refers to powers is potentially significant, especially as the Constitution is scrupulous in reserving the term rights for persons and the term powers for state and federal governments. A holistic approach is interpretive if it helps us resolve problems of ambiguity in which words have more than one meaning. Think of the words, for example, arms in the Second Amendment that could refer either to weapons or the limbs to which our hands are attached. In his lengthy exposition, I do not believe Burt offers any examples of textual ambiguity that are resolved by his holistic approach, though I could be wrong about this. Now, holism could also be interpretive if it reduces the apparent vagueness of terms by rendering a seemingly general or abstract term more specific in context that it may first appear. For example, while the term due process may be vague, the phrase due process of law may be less so, and the additional information about its meaning may be supplied by its juxtaposition in the 14th Amendment with the Privileges or Immunities Clause and the Equal Protection Clause. Again, I don't think that Burt provides any examples of constitutional terms that were rendered more specific or, for that matter, less specific as a result of holistic analysis, but I think it's certainly a logical possibility. So although I would not rule out the value of holistic analysis to resolve interpretive issues of ambiguity or vagueness, I actually think that the thrust of Burt's thesis is really to provide a holistic approach to constitutional construction rather than interpretation. By this I mean he is not using his method to identify the meaning of the text, but rather to provide a way to decide cases where the meaning of the text is too vague to resolve a particular case or controversy. Now, as I said, since constitutional construction is inevitable, perhaps holism provides a good approach. But I think Burt fails to provide any normative justification for why we should adopt his holistic approach when the meaning of the text has run out. Perhaps he can do this, and I don't wish to deny that such a justification is possible, but the burden is on him to do so before we should consider adopting his approach, if it's an approach towards constitutional construction. As it is, a holistic approach, I think, remains an intriguing and, yes, even poetic way to look at the text, but I see no argument for why this is a way to decide cases when the meaning of the text has run out. Now, unfortunately, however, I also see a danger in Burt's holistic approach, which will be the final point I make this morning. In various places, it looks to me like he is using the approach neither to interpret the meaning of the text nor to construct constitutional doctrine by which its indeterminate meaning can be applied to particular cases and controversies. Instead, he seems to be using his holistic approach to supersede or contradict the text. For example, his holistic approach tells him that the Second Amendment does not protect an individual right to keep and bear their own private arms, which was the universally recognized condition of maintaining a well-regulated militia. Instead, through a longer and elaborate analysis that I can't replicate here, he reads the amendment as protecting an individual right to serve in the armed forces or local police department that he thinks are analogous to the militia. Now, I don't have time to enumerate all that might be wrong with this proposition, but the most obvious problem is that it is not at all what the text says, by any reasonable interpretation, and is a proposition that could easily have been expressed had that been its intended meaning. Moreover, I found his reasons for rejecting the individual rights interpretation of the Second Amendment to be wholly unpersuasive.